Lisa Lockwood, you're a crime analyst. Now, I've been involved in a number of high-profile cases where there has been blood spots or spots, because they're not necessarily blood, they're just spots that you see that need to be analyzed. Now, there was several spots in the same pocket that the knife was in, if I recall, of Mr. Cleereman. They were never analyzed. Is there a reason to analyze them, and would it be helpful to the prosecution or the defense?
Well, the benefit of analyzing them is to find out whose blood it was. So if it was indeed his blood in his pocket, that would go with the theory that that knife was out, and the transfer from that pocket knife back into his pocket, with the theory that his wife was fumbling and touching him, put it back in there. But then if we looked a little bit further and examined the pocket knife to check and see if her fingerprints were on the pocket knife, and she did have a part in trying to put the knife away so there wasn't any conversation regarding, he went after him with the knife first, and Edgecomb retaliated using lethal force because that was upon him. So I think that would have benefited everybody if we had that analysis.
To even see if it were blood, it would have something that we could even go further on. Lisa Lockwood, that's actually not what the defendant said, because I was here when he said it. He said, quote, I could see he was holding something but could not see what it was. That's what Theodore Edgecomb testified to. Now, if I am the defense attorney, I would get that transcript immediately and, quite frankly, shove it down the prosecution's throat. But that doesn't seem to be what's happening here. What are your thoughts?
He did, correct. And I do remember that testimony. And I also remember him saying there was an item. I couldn't make out what it was. There was an item. So he never said it was a weapon, but there was something he felt was in his hand. And even if he had the pocket knife and it was not flipped out into the open position, he said he saw something. But we also have 4 witnesses who said he was in a stance, a boxer stance. So could he have hidden the pocket knife folded in his hand in a boxer stance? For sure. There's a possibility that that was there and the other witnesses weren't able to see that. But if it were flipped open in a position of actually attempting to kill him or use it, and the knife is in an engaged position, the likelihood of all the witnesses, including Edgecomb, could have obviously said, yes, I saw a knife, and that's when I felt the need to do that.
We're going to now go back, Lisa, and we're going to go back, Lisa and Andrew, into court because the judge is on the bench. We're live. Lisa Lockwood, crime analyst, let's talk about this a little bit. Mr. Ivory Lamar may have started slow, but he seems to have ended a little bit stronger, talking about, well, you can talk about it's a jog. I talk about that my client was being hunted. What are your thoughts?
I think he achieved what he wanted to, and it was very favorable in that he exposed that there was shoddy police work. The investigation wasn't full. The burden of proof to prove whether or not the weapon, the pocket knife, was in his hand or not in his hand, the state was not able to prove that, and that has to do with shoddy police work. So if these circumstances were true, and he did, Mr. Cleereman did have a knife in his hand, it would be justified for for Theodore Edgecomb to do what he did, is to retaliate with the use of lethal force because of lethal force coming in his direction. So I think he did a great job in that regard.
Yeah. And Lisa Lockwood, let me ask you about this. I had Judge Fanon, retired Judge Fanon Rucker, on yesterday, and we talked for a long time about there is a definite issue about race in this case, and that has to do with Edgecomb's testimony, that he felt that, look, he ran, he killed a white man, he learned a couple days later he was dead, that he was listed as a prominent civil rights lawyer. He felt he didn't have a chance, given his history, to have a fair break here and a fair story. True?
I think that was an important piece. And what I would have liked to have seen is the defense attorney actually showing all of the proof of him seeking an attorney. Back that up with phone calls. When was the GoFundMe created? If all of that was there, then there would be that reasonable doubt of the reason that he didn't turn himself in, because he thought he wasn't going to get a fair shake in all of this, because of George Floyd, because of Sandra Bland, because of Ahmaud Arbery. Two of those happened in 2020, right before this happened. So they were prevalent cases. Could he reasonably believe he wouldn't get a fair shake? Yes, without a doubt. But I would have had that backing information proving that he was seeking attorneys. Phone calls were made. Let's look at phone records. Let's see who you spoke to or your fiance spoke to.
Lisa Lockwood, crime analyst, former SWAT. Okay, let's talk about this. This was a very passionate rebuttal argument, but did it do its job? Because it seems to me the prosecutor said, well, he says he's not a killer, but he killed somebody. But that's not the issue here, is it?
It's not. It still goes back to self-defense and what was his mindset in that moment. And even when we had the use of force expert, John Black, on, and he talked about all the different perspectives. Edgecomb, when he was actually being interviewed by the defense attorney, he said, I saw a car pulling up. I saw the wife there. I had all these things that were happening, and it was a split-second decision when I pulled out my gun because I needed to protect myself. So there are pieces that could have been elaborated a lot more with the defense attorney to help his client. But I think in the end, if you're going to ask me, I think the prosecution was able to prove more so in a lesser charge.